My name is Tom Hisney. I'm with the Development Services Department, and this is our outreach meeting for the current round of amendments to the Land Development Code. I'm going to be joined tonight by Israel Monsanto and Mike Williams. And if during the course of this presentation, we're going to pause after each description of each amendment in case there are any questions from anyone who has joined this meeting. So with that, we'll get underway. So in this round of amendments, there are several key dates that you see on the screen before you. This is the public outreach meeting. It will be followed by a public hearing in front of the Board of County Commissioners on September 30th. Then there will be a meeting in front of the Hillsborough Planning Commission on October 4th. They will make a finding as to whether they believe the amendments are consistent with the comprehensive plan. And then finally, there is a second public hearing in front of the Board of County Commissioners on October 21st, at which time they will vote whether to adopt the proposed amendments. There are 5 amendments that are under consideration currently. I will now go and describe, again, we'll go through the amendments one at a time. So the first amendment that we'll discuss is Amendment 21-1044. This is an amendment to the Land Development Code, regulations regarding wet zonings, technically alcoholic beverage permits. The state recently made some amendments to their licensing laws, which allows package sales by certain eating establishments. We felt it necessary then to be consistent with that to change our land development code with regards to the types of uses permitted under our wet zoning. We have a number of wet zonings. They typically end with an X, which prohibit package sales. So we are amending the code to identify that, notwithstanding the X, that certain eating establishments will be allowed to have package sales in accordance with the requirements of the new state law and their licensing. This change will not affect, is not carte blanche. It's not across the board that all wet zone establishments with the X the category will be allowed package sales. The package sales will be restricted to the certain eating establishments per those state laws. Additionally, we are making a revision to the notice requirements for wet zonings that are unique to wet zoning, and we're going to change that notice deadline to coincide with the same notice deadline for all the other types of cases that go to the land use hearing officer. I don't believe we have any members of the public logged in, so we will now go to the second amendment. This one is the Amendment 21-1045. This deals with garbage and recycling infrastructure requirements for new construction, commercial and multifamily development. This amendment, if adopted, will require that those projects provide adequate space for garbage and recycling dumpsters. This amendment will ensure compliance with Florida statutes. It will also further the county's sustainable material management goals and will reduce litter and improve community appearance. Next slide, please. Next amendment is 21-1046. This amendment will establish a time frame for hearing applications that are reopened or remanded. Currently, our code establishes a 6-month time frame in which a application must go to hearing. However, that time frame applies only to the original hearing date. And so if an application is opened and then continued to a later hearing by the hearing officer for whatever reasons there might be, or if the case gets remanded back to the hearing officer by the Board of County Commissioners, that 6-month time frame no longer applies to that case. And so this amendment will impose that 6-month time limit on cases that are reopened or remanded. Next slide. This amendment 21-1047 is to clarify the review process in the LDC for transportation issues such as connectivity, cross-access, access point, and other related criteria as part of a plan development rezoning process. Specify that transportation information on the PD site plan, through the PD variation for site design, and each individual request for the variation must be processed in accordance with the applicable administrative variance process, which is consistent with current practice. And then other items have been included to the list of transportation information that's required for plan development plans in the submittal of those results. Next slide, please. This is 21-1156. This is a change to the home-based business regulations found in the Land Development Code. These changes are needed to comport with new state law that went into effect on July 1st and largely preempts the ability of local jurisdictions to regulate businesses. The changes will include, but are not limited to, elimination of the need for approval of a conditional use zoning permit for the home-based business. It will result in a broad expansion of the types of business that may operate from residential homes, and it will allow for non-resident employees in residential zoning districts. Again, these rules do that preemptive state statute went into effect on July 1st, and again, this amendment is really just to conform our regulations to the new state statute. That concludes the briefing. I believe we still do not have anyone of the public logged into this meeting. Is that correct, James? James? Or?
Yes, sir.
All right. So with that, then we will conclude this meeting.
Understood. Record has stopped. We are adjourned.
Thank you.